Welcome, everybody. My name is Paul Adamson, Chairman of Forum Global. I'm going to be your moderator for this first session of the conference. I'd hoped you've been listening to a very provocative and thought-provoking intervention by Senator Sherrod Brown, teeing up our first panel discussion of the conference, which is entitled People, Industry and Government, What Do the Next 4 Years Hold for the Data Privacy in the United States? The session we will just examine in the 60 minutes allowed to us the progress made around the developments of regulatory concepts that could inspire a future federal data privacy law, and debate remaining sticking points around sectorial and state law, preemption, privacy, right of actions, costs of compliance, and the nature of enforcement. We'll move on to discuss the impact of the California Consumer Privacy Act that it has had on the US privacy landscape as a whole, and we'll ask whether a single privacy framework that remains future-proof and flexible to company data needs can ever be achieved in the United States. And finally, of course, ahead of November's presidential and congressional elections, we will discuss the lessons learned from the various attempts at introducing and passing a bipartisan bill, which could inspire future efforts by the next administration and Congress. We have an extremely expert panel to discuss all these different aspects of the debate. Cameron Kerry, Distinguished Visiting Fellow at the Center for Technology Innovation at Brookings. Michelle Richardson, who's Director of the Privacy and Data Project of the Center for Democracy and Technology. Sheila Cocklusier, Global Chief Digital Responsibility and Public Policy Officer at Kinesso. And Jerry Jones, Executive Vice President, Chief Ethics and Legal Officer at LiveRamp. So this session, everybody under my panel is kind of crystal ball gazing. So you have a few minutes each of you to get out your crystal balls and share your predictions with us. Starting with you, Cam, over to you.
Well, thank you, Paul. It's good to be here and be with this group. So in some sense, I think the main event today is a hearing of the Senate Commerce Committee, which is entitled Revisiting the Need for Privacy Legislation. And I think that title sort of expresses where we are in the debate today. It is the Senate Commerce Committee in particular has put in a lot of work on privacy legislation, as have other committees, the House counterpart, Senator Brown's Banking Committee, but have not succeeded. And I think this hearing is really saying, look, privacy is still on the agenda, and consolidating the work that has been done and setting a marker for the next Congress. The hearing also comes on the heels of Senator Wicker, the chairman of the Commerce Committee, and other Republicans filing a bill. That bill is based on the draft bill that Senator Wicker and his staff put out late last year, and is substantially the same in the provisions that they put out. There are a few changes in what they had. The only major differences are the addition of provisions out of other bills by other sponsors of this bill, dealing with choice architecture and with algorithms. So really, taking a few things and saying, this is our position, but there are obviously no Democratic sponsors, and some other significant Republicans, Senator Blackburn, Senator Moran, have had their own bills and are not on this bill. I will be interested to see at today's hearing, which features several former FTC commissioners who testified to Congress before, and California AG Xavier Becerra, who is not. I'll be particularly interested to see what Attorney General Becerra has to say about preemption and about California legislation, both the existing CCPA and the CPRA, the California Privacy Rights Act, that is on the ballot this fall. What we've seen in the debate so far is, Senator Wicker's bill and the legislation that Senator Cantwell and other Democratic senators introduced late last year have a lot of points in common to an extent that surprised me and surprised, and I think the sort of level of comfort that I found in both civil society and business side also surprised me. But they are within shouting distance of each other on a lot of the major issues about individual rights, the scope of collection, the main lines of enforcement. They are poles apart when it comes to preemption and to private rights of action, and that is really what has stalled the debate. Looking ahead, obviously much depends on the outcome of the election. The choice of the president will certainly have an impact. Joe Biden is on record as supporting comprehensive privacy legislation, along the lines that are without a lot of specifics, but along the lines that have been under discussion. The Trump administration had a process on privacy that has died on the vine. But certainly in Congress, there will be an effort, whichever party is in control of the Senate, to move forward. And I think much of that leadership will be in the Congress. But this will be on the agenda. There will obviously be a lot of major issues to face early in the Congress, but I do believe that it's possible in the next Congress to get legislation passed. The hearing today is certainly as I've said, a reminder that this issue is still on the table. A lot of work has been done by the Senate Commerce Committee, by Senator Brown and his very interesting proposal, and this work will continue. And I am optimistic that in 2021 or 2022 we can see the passage of comprehensive privacy legislation.
Cam, I now turn to Michelle. Over to you, Michelle.
Thank you. Well, we've had a lot of exciting developments here in the U.S. since this conference last year. And as we wind down this congressional session, very happy to report that we probably have 10 to 15 comprehensive privacy bills at this point from both Democrats and Republicans. And there's even more if you consider the ones that are being filed on very specific issues like facial recognition technology or health data. And it shows a sincere interest in Congress in legislating here in a way we just haven't seen before. So we've had multiple hearings through different committees, and they've brought in CEOs, advocates, academics, the FTC itself, in another hearing that will start at 10 o'clock this morning to collect testimony. They've sent oversight letters and requested investigations from the FTC. So we are heading towards a federal solution here. As Cam mentioned, there is an emerging consensus of the general scope and some of the areas like individual rights, transparency, opt-in for sensitive data, and that there will be some limited rulemaking for the FTC, as well as some expanded authorities. This sounds like a very basic list, but 2 years ago, a lot of those things were not clear, right? We were still debating things like, will portability make a bill? Are we talking opt-in or opt-out? So it's been hard fought, but we are making progress. Looking forward to the policy work that's still left to be done, though. I think we're looking at the states, right, coming back in January and starting their legislative sessions. It's very hard to pass state legislation. We've seen this sort of struggle in Washington, New York, and other places, and it's not clear whether next year we will see any new state laws. But I think it's instructive, right? We see the debates that are happening there, the different language. It's stress testing a lot of things that we just haven't gotten to yet here at the federal level. And I think we have a few key areas. I'm not going to talk about preemption and private right of action today, but two other things. One is just a core collection of issues that are just fundamentally about the collection and use of data outside of notice and consent. Despite the fact that we are all saying we're tired of notice and consent, we need an alternative, we are still having a little hiccup of getting to the next step of then saying that means we have to change fundamentally how companies behave. If we are actually shifting the burden from people back to companies, we have to make some clearer rules and realize that there is a risk, right, associated with that, but it will now be shared with companies, won't be solely on people. And what that looks like is a continued debate around minimization and how to frame minimization. There's also a debate around artificial intelligence and whether and how a bill should tackle that issue. We've seen this pop up in more and more proposals, and it's likely going to be something required to get bipartisan support. And also civil rights. There is justified and urgent concern that our existing statutes are becoming out of date and not tracking with how technology has developed and is using data. And finding a solution in those three areas is going to be very important for moving forward. I'd flag the second category, though, of things that I think are maybe sleeper issues that we've seen the states try to wrestle with, and a difference among the bills. They maybe aren't as sexy. They are not making headlines, but they have some pretty profound effects on what a federal law would look like. And I think once we start getting to the markup stage, we're going to see some divisions between Democrats and Republicans, advocates and companies, and maybe even fissures within industry itself. These are things like fundamentally how we're defining covered information, especially how we're going to treat pseudonymous data. The scope of a small business exception. Is this going to take small businesses completely outside of the scope of the bill, or it will just lessen their obligations? Liability for vendor or third-party use of data. I think it's going to be very controversial, but it is now a piece of accountability that we see in FTC settlements, and is going to be important for larger companies to have. Will there be a safe harbor or some sort of certification program? We know this is important to industry. It's shown up in a couple of bills, and we need to start discussing what that looks like if it is going to be included. And finally, data security. We've seen some proposals creep up that really limit the impact of data security requirements by limiting the data that's covered. And so I think there will be a debate about what that looks like. Finally, I would flag for people that we do have to consider where this issue fits in the larger ecosystem. We have a lot of issues that are in the deck on tech policy that will go through the same committees and sometimes get packaged together. So I do wonder, for example, if there's a change in the administration and we take months to do that process, right? Someone recently reminded me that is actually a very involved process. But we also have things like content moderation, 230, encryption, antitrust. I think there's an open question about how Congress will sequence those issues and where this is going to fall. I would like to make the case that this should go early in the process because more work has been done here, I think, than in maybe some of these other areas. Mm-hmm. And I think we need to just make some decisions about the other already regulated industries. I think we've had finance, health, ed tech, waiting in the wings, maybe indecisive about whether they want to get in on this regulatory moment, and they need to make a decision here. I think this is going to move forward without them, right, if they don't move quickly. But there is still time if the committees of jurisdiction and industry and advocates come together to make them part of that. But we will move forward without them, I think, is a clear message. So that is the big picture looking at the next year or two. We are focusing in on some of the most important issues at this point, and I think Congress is gearing up to make some serious moves next year.
Hey, thank you very much, Michelle. I have lots of questions already for the panelists who have already spoken, but I'll bite my tongue and instead give the floor to Sheila.
Hello, thank you very much for this wonderful panel, and I'm very honored to be included today, and thank you so much. I'm a practitioner, and I have been for 25 years, having started before that my career in the U.S. Senate and then worked in Washington for quite a long while. I now work in data and tech, and again have for 25 years being a practitioner of how you govern data. And I want to highlight a couple of things that are realities. Number one, every country in the world has an industrial policy. And just about every country in the world's industrial policy is digital policy. The language of digital is data. And not all data is the same, but it's collected data or active data, observed data, and created data. Data is as important as currency. It is, if you will, the currency of the digital age. And we desperately need a federally preemptive law that matches our industrial policy here in the United States. And there are other countries in the world that have or are in the process of marrying up their industrial policy that drives their economy and their data policy, bringing the two together so that data protection is done in a way that's very future prepared. And I'll reference Singapore is in the midst of this, and Canada is actually taking a fresh look. And I also want to point out that our societies, our economies already were in a period of rapid digital adoption. We were becoming digital citizens, and the pandemic has flipped the script. We have pivoted to digital first work, commerce, economy, social interaction, and this makes the imperative of a future-looking U.S. law critical. Remember that human behavior change is the most challenging thing we'll face. It could be what Michelle talked about, getting companies that collect and use data to change their behavior. These are people. And as we have flipped the script and become digital first, I don't think we'll go back to the way it was once we sort of get the pandemic under control. The third thing I want to point out that really underpins the need for U.S. federally preemptive law that is future prepared and really grapples the reality of a digital first world is that legislation is a codification of our social norms, our cultural values. So a law of the land in the United States has to ensure that we live in service to people, that there is fairness, that it protects competition and innovation. And we heard that from FTC Commissioner Christine Wilson earlier this morning. The fourth thing I'll point out is, in addition to the pivot to digital first, we are about to experience accelerated computing and advanced algorithms on a scale and at a rate, speed, and velocity we've never seen before. This is AI, and everything will become AI everything. It's coming. So we need a federal law that enables all of us to compete here in the United States, that enables the United States to compete on the global stage, that puts people first, that protects democracy, freedom of speech, and enables data to serve people fairly. We also need strong enforcement by expert authority. I think the FTC is the right authority. we have the intersecting issues of antitrust. These are very important, and I like the way Michelle put it. It's the sequencing of issues, and I have faith in our Congress that we'll be able to address that intersecting issue so that data flows accountably and fairly. I do want to also call out something that Michelle named, and this is the accountability notion. I hope we end up with a future prepared law that sees us not just 3 years, 5 years, but all the way to 2030, and is not backwards looking, something that grapples the reality that data is currency, that if our economy wants to compete and we want innovation and competition, data has to flow accountably. And I want to talk about accountability for just a moment, and consent. And, Senator Brown talked about this as well earlier, that people don't read privacy policies. And when they do, they're very legalese, which they need to be for us to be legally compliant, but people don't read them, don't understand them. And there's sort of a forcing function because we have a digital imperative and we're living digital first lives. If you want to participate, you're forced through a consenting function. I don't think that's the right way to approach a national federally preemptive data privacy law. I think it goes to the use of data and the use of algorithms. And I think that accountability has to be shifted back to the collectors and users and sharers of data. And I think I want to introduce a term called demonstrable accountability. It has to be enforceable. The other thing I think is very important, marketing and advertising get picked on a lot. And actually every entity has to market and advertise. So we need systems of accountability that protect and preserve the ability for people to connect with brands and for brands to connect with people, again, in a fair, accountable manner. Thank you.
Thank you very much, Sheila. Jerry, over to you.
Well, good morning, everybody. And I had to chuckle when, the opening question was, what can we predict about the next 4 years? I don't know about y'all, but I'd really like to know what's going to happen over the next 40 some odd days, because there is so much happening that we'll get a little more clarity in about a month and a half as to where we're going to go in a lot of different things. But specifically with respect to a possible privacy law, let me frame a couple of things. The Democrats are going to control the House of Representatives. That's going to happen again. We know that they have a sufficient majority to get a bill out. But what about the Senate? The control of the Senate is very much going to be up in the air. If the Republicans maintain the control, I doubt that they will have the 60 votes necessary to overcome a filibuster and vote for closure. And likewise, if the Democrats obtain control, I think we'll be in the same situation. So one of the determinants on whether or not something's going to get done is what happens with the filibuster rule, which of course may or may not come into play depending upon which side has power. And that power is going to be exercised not necessarily for privacy reasons, but for other types of reasons, in particular the potential makeup of the United States Supreme Court. As Cam and others have said this morning, there are really two missing pieces that have got to be solved in order for the United States Senate to get to where there's going to be bipartisan support for a bill. And there's going to, as I mentioned, there's going to have to be bipartisan support, in my view. And of course, that's preemption of state laws and whether or not there's going to be a private right of action. And if so, what are its parameters? So we know the puzzle's got to be solved. And one of the things that helps us in solving this puzzle is there's a lot of momentum going on right now. And there's a wide consensus in the US that we need a comprehensive data privacy law that properly balances the interests of people, society at large, government, and business, fosters a level playing field, and allows America to continue to think with data for many of the reasons that Sheila just mentioned. But how do we get there? I mean, my goodness, for the last 20 years, good people in Congress have been trying to get us a national data privacy law, but we haven't gotten there. So today I want to focus on the private right of action issue because in my view, if the private right of action issue is resolved, then it makes the preemption issue much easier, because I don't see how you can agree to preemption if you're a little hesitant about it until you know what the substantive provisions of a federal law are going to look like, so that you can compare it with the various state laws. So I also have to share with you that I come from this issue from a different perspective. For almost 20 years, I tried lawsuits, all kinds, and I tried them to cases. I tried cases to judges and juries. I defended very large and dangerous class action lawsuits for my clients, and also represented plaintiffs every once in a while in large national class actions where my team and I did our dead level best to make those dangerous for the defendants. And then for the last 20 some odd years, I've been the general counsel first at Axiom and now at LiveRamp. So I kind of know the pressure and pain points from both sides of a lawsuit or litigation, and the pressure and pain points from being within the industry for 20 some odd years. I also have to say that from my experience, I trust the American judicial system to get it right. Almost every time they get it right when they're allowed to do so. Now, of course, there are going to be some aberrations, but the vast majority of times, the American judicial system gets things right. So I don't have fear in the American judicial system. Rather, I have trust in it. But sometimes the laws tilt too far in the direction of one side or the other. And many times they tilt too far in favor of a plaintiff when the defendant might win the case 99 times out of 100. But the potential liability on that one chance is so high that the defendant, in the exercise of prudence, really has no other alternative except to settle and pay a lot of money. That is particularly true in the situation where you combine a statutory amount for a violation with the vehicle of a class action. It really does create an interesting and, I would contend, unlevel playing field. Now, some, of course, will say that because damages are so hard to prove for a privacy violation, that the law's got to give the plaintiff a little bit of help and impose a statutory amount. That's kind of a circular argument, because there's good reason why damages are hard to prove in such a case. It's because most of the time, in many cases, not all, but in many cases, they just don't exist. And why? There's no real harm, no cognizable harm. But if we put in place the type of accountability that Sheila was talking about, along with some other things that I'm going to mention in a minute, I think that we can mitigate the need for a full-fledged, unfettered private right of action with a limited private right of action, and perhaps put the puzzle together. So where am I going with this? Well, perhaps I'm out on a limb. After all, I work for a company that is in business because of the data that we use and the data that is available. But we got to do something. And in July, I authored an op-ed in TechCrunch where I suggested a path where I thought the common ground could be found. And I went against the general stance of the industry to just say no to any type of private right of action. Why did I do it? Well, first, the attempts to get something done in the Senate had pretty much floundered upon the rocks because, for very good political reasons, no one was really ready to put all their cards out on the table and make the big first opening move towards common ground. And as Cam and his co-authors have pointed out in their wonderful 80-page report from the Brookings Institute, if the respective sides in the Senate, and in particular the Commerce Committee, stay in their corners, nothing is going to get done. Secondly, let's be honest about this. Why should our industry be the only industry with immunity against being held judicially accountable if we do something that is a material and substantial violation of the privacy statute, whatever it may be, that directly causes physical injury or substantial financial harm to a person? Or if we repeatedly stiff somebody when they want access to their data or opt out or correction, for instance. So if we can construct a framework where we properly resource the agency of record, the FTC, give it the resources that it needs to do its job, both in money, authority, and personnel and experts. Give the state AGs backup enforcement authority. You know, American business has a pretty good record of actually following what the FTC creates in the FTC common law through consent judgments and settlements. But the FTC is constrained because they just don't have sufficient resources to do everything they need to do. Additionally, if we require companies to conduct privacy impact of a proper size company to conduct privacy impact assessments, if we require properly sized companies to conduct audits of data collection and use, certify those audits and file them, perhaps with the FTC, analogous to what a public company has to do with our financial information anyway, then we have a paradigm that would engender a higher level of compliance. And the US, I would contend, would be taking our rightful place alongside our friends from the EU as data privacy superpowers, where we have abdicated our responsibility, but we got to get back up there. And so I don't think that you need a full-fledged private right of action if we put these types of things in place. But perhaps we're not all the way home. And we still need room for the societal pressure relief valve of the availability of the assistance of our judicial system. So let me be very specific about what my proposal is. In order for a person to file and prevail in a suit for a violation of the federal data privacy law, whatever it may be, they have the burden to prove the following three things. One, they have to be able to show a material and substantial violation of the statute. Two, that is a direct causal result of the material and substantial violation, they have suffered harm. And third, that the harm has to be substantial economic or physical harm to the person. Two other pieces. One, any such suit has to be brought within the United States District Court, the federal court system. Why? So that we can have consistency of interpretation of the federal statute across the breadth of the United States. And secondly, the judicial system, of course, has to be open for equitable or injunctive relief if a company is not complying with its obligation, whatever they may be, under the statute for such things as access, correction, or deletion. And the government's and the company has been given a reasonable opportunity of time to cure. So if these could be the puzzle pieces for a limited private right of action, perhaps that will be something where we can build enough common ground to actually move a statute, a bill, into a law. As Senator Blumenthal said at one of the hearings last fall, you know, we've got plenty of bills. What we need is a law. And all sides to this issue have got to understand that if we don't come up with a comprehensive national data privacy law in the United States, then it is inevitable that the states are going to continue to enact laws. The counties are going to enact laws. The cities will probably enact laws. And maybe my own neighborhood will enact a law. And it will be very, very difficult for people to know what their rights are as they move about the country. And it will be very difficult for companies to be able to navigate all these things. And if it is that complicated, it will stifle innovation. It will be a large barrier to entry by new companies because of the expense of figuring all this out is going to be very substantial. And it really will entrench the big guys like Google and Facebook. It's inevitable.
Okay, Jerry, I need to bring you.
So one more comment. I would, because this is very important. We need to have a very serious conversation about this. I would urge you to go back and talk to your companies, your senior leadership, about whether or not you're willing to do something on this. And I would be more than happy to talk to your leadership teams about why we should consider finding this common ground. Thank you. And I know it took some time.
Yeah, it's kind of ironic, Jerry, because you were so worried about being the last speaker on the panel and not having enough to say, but I think you've proven the contrary, my friend. Thank you very much indeed, Jerry. Now the discussion part of the few minutes we have left to us. Now, there are three elements of this discussion now. One is people on the panel spontaneously wanting to react to what they've heard from the fellow. Cam wants to come in a second. He will do, but one second, Cam, one second. Secondly, I would like to ask you, if I have time, things I've heard as well from other panelists to react. And last but not least, the audience, the very patient audience, there's quite a queue of questions lining up. So I feel duty bound to include them as well. But first, I did promise Cam he could respond to Jerry on the private right of action issue.
Well, thank you. Thank you, Paul. And Jerry, thank you, for both mentioning our Brookings report on legislation and sort of trying to identify a path forward in the debate. And thank you, more importantly, for really biting the bullet on private right of action and saying that we need some form of private right of action. It's something I've heard from a lot of people inside companies privately. But the fact that you said it publicly, I think, is a valuable contribution to the debate. And we have in that Brookings report, I think, a solution of a couple of grand bargains. I mean, one is preemption for some form of private right of action. We should have preemptive legislation in the United States. It's important for the country, for our competitiveness, so that we can go out in the world and deal with Europe. Companies have that trust. It's important for our leadership, as you said. We should be aligned with the democratic countries that treat privacy as a fundamental right, and it's important for companies to have a consistent standards and not tailoring your compliance in different ways, and important for consumers. This is about trust, and consumers need to be able to trust, what they're dealing with without having to, figure out different state standards, different protections. They ought to have the same expectations, whatever sector they're dealing with, wherever they are. But we do have important interests in privacy that have long been protected by law. So a serious invasion of privacy, let's say non-consensual porn, ought to be protected with a remedy. Financial injury, as you mentioned, ought to be protected with a remedy. And I think it's hard to argue against that. So I think there's room to come together there. The other grand bargain that we propose is, limits on collection use, transfer, but really looking at things on a risk-based approach, and trading off some flexibility and also, honestly, a little bit of vagueness, but allowing adaptability so it's future-proof, so it applies to different situations, and so that it's scalable to different sizes of companies, different obligations at different levels. And I think that's an approach that in some respects would be stronger, I think, than GDPR. It's not one size fits all, but in a way that also reflects sort of the adaptability, the iterative approach that we have in a common law system and that we have in evolving technology. So I think that's an approach we can work around.
Thank you, Cam. There's quite a traffic jam of questions lining up, so I feel duty bound to bring in the questions from the audience. The first one from Teresa Berlin from Save Our Privacy, and she touches on a very important point that I think all of you in different ways have referred to in your own interventions. Her question is the following. Considering the number of bills and draft proposals on data privacy that have been circulated by members in both chambers, do the panelists see this as real progress or proof that we will never reach compromise on these stumbling blocks, preemption and private rights of action? Michelle, you talked about in your intervention about you didn't think there'd be many examples next year, at least, of state initiatives. So how would you respond to Teresa's question?
You know, I think it's a good sign. This is how legislation works in the US, especially something that's this complicated and there's so many interests at stake. So I would not see it as a sign of failure. It takes time, right? These things take 5 years, maybe sometimes longer. I think the good news is that we are maybe on year 2, 3, 4, right? Depending on where you start counting. And it's it reflects genuine interest. So I think this is all moving in the right direction, even if we have some.
Thank you. Anybody else want to come in to respond to Teresa's question?
One quick comment on that. If you lay Senator Wicker's proposed bill beside Senator Cantwell's proposed bill, you will see that there is a lot of agreement on many of the core principles. And it's really a guideline to negotiations between their points of view broke down about this time last summer. So, when you're trying to get an agreement on 100 things, if you've got 80 things already agreed, you've made a lot of progress. So I actually view it as a positive thing that we know the respective positions and we know where the bridges have to be built in order to get bipartisan support.
Thank you, Jerry. Anybody else before I move on to the next question? Michelle. Yeah, please do, Michelle.
Just jumping into underscore it. I think it's a good sign. It, as Jerry says, it surfaces where the concerns are. This is a fundamental matter of our daily human lives and our economy and commerce. So very important. And we do need to understand where all the issues lie so that we can address them thoughtfully. And as Jerry said, build the bridges. Remember, there's a difference between good policy and good politics. So there is some politics at play. But there's two sort of momentum streams that we need to be very conscious of. One is aligning Congress, and the second one is aligning business. Remember, united we stand, divided we fall. So business itself is not completely aligned yet. I think we as our Congress works, it's the greatest judicial system in the world, and we do stand for freedom, democracy, and justice for all. And we are working on those issues, and we need to work on those issues in data privacy. So in the business sector, one of the things that absolutely has to happen is we have to have a coming together and build our own bridges so that when we interface with Congress, we can move the ball forward. And I do want to shout out to Cam and his very important work at Brookings. This is a great example of thought work that has been put forward that is fair and good for all of us. And I just want to publicly thank Cam for that important piece of work.
Okay, I'm going to move on to the next question because there are quite a few. And this one is so dense, it's actually in two parts. So panel, pay attention. A question from Jonathan Kay, fellow at the Alan Turing Institute. Question to all of you relating to algorithm bias. So pay attention. I know what can be done on bias, says Jonathan, along lines of protected characteristics, but a deep learning algorithm might classify, discriminate against people based on an invisible or non-explicable combination of characteristics, effectively discriminating against me because of what others have done. Is anything being done in relation to explicable AI or some kind of rule on how such algorithms work? And then part two of Jonathan's question, he gives an example: autonomous vehicles. Law based on holding people or organizations accountable for their machines has its limits. They may not be able to know what is going on or what will happen if they change their behavior, but using, for example, machine learning to detect or prove violations has its own weaknesses, including the embedding of bias in the code. Can the legislature and judiciary tackle this in time? Wow. Anybody want to take a stab at answering that? Cam?
I'm happy to jump in. Look, I think there is an important way to deal with this that we have in existing civil rights law in the United States that we need to reinforce. And that is the notion of disparate impact and of putting the burden on the party that is using the technology to justify discrimination. So we do that in the employment context. If there's a disparity in race or gender, the burden has been on the employer to show that there are legitimate occupational qualifications that are responsible for the decisions. And right now there's a trend to weaken the disparate impact test. It needs to be strengthened, especially in the algorithmic context. It should machines should not be allowed to discriminate where humans cannot, and it should not be a defense to a discrimination case to say, well, the algorithm did it. So the sponsor of the algorithm needs to prove that it's fair, that it's non-discriminatory.
Thank you, Ken. Michelle, I promised the floor to Michelle through the chat. So Michelle, then you, Sheila. Michelle.
Yeah, I was just going to say, Jonathan, quickly that this question of proxies actually has been litigated for decades, right, under civil rights laws. So this is not the first time we're tackling it.
Mm-hmm.
It feels new, right, to people in technology, but we have models that we can jump off of, like Cam mentioned. So it really isn't all that untested. You make people responsible for the outcome of their decisions. Doesn't matter how they got there, right? And they go back and fix it however they want. But we measure how they treat people at the end of the day. And that is a perfectly fine model for dealing with AI specifically too in this area.
Thank you. Sheila.
I was going to jump in and offer that, there's a really important academic underpinning to this conversation, which goes through the practice. Remember, it's you have thought leadership. Yes, we all want to do the right thing. Yes, we need to hold our algorithms accountable. Yes, they need to be explainable, correctable, and deliver impact and consequences that are fair. But in the practice of that, I want to introduce something called the Unified Ethical Framework, which is a practice methodology where you characterize the project, the scope, the outcome, surface all the data, all the facts related to the data. It's a very comprehensive practice approach to designing algorithms, but really holding the impact and consequence to people accountable. Many of us, are working in this area to devise a way forward so that we can be certain about the impact and consequence of algorithmic work we do, because AI driven, everything is, as I said earlier, coming online very, very quickly. So we all agree we need to do the right thing. Good actors agree we need to do the right thing to train our algorithms. We need massive amounts of data, good data, bad data, so we can train it to detect and prevent bias and discrimination. Justice really matters. It's the underpinning of the United States. We believe in it. And those of us that are practicing in the field, we're trying very hard to get it right. And this ties in to the need for federal legislation that allows the data to flow and be available instead of, it's really less about collection of data, because remember, there's actively collected data, observed data, created, inferred, derived data. Data's become infinite. And I really think it's folly to think that we can put the toothpaste back in the tube. It's really, we need to focus in on the use of data and fair outcomes and demonstrable accountability.
One final comment on this. I mentioned it, and we've been trying to get a federal data privacy law for the last 20 years. Well, here's the thing with technology. It advances so much faster than the law does. And it advances faster than human beings evolve. I mean, the human person has not evolved much in the last couple of 100 years, but what technology has. So we've got to figure out a way for our boundaries to be able to set in a much faster fashion, where technology gets such a lead and companies will get such a lead on things that the law is going to be way behind. The other thing I'd like to say about AI is it is the next arms race. I mean, it is, if you take it all the way to strategic considerations. And the world, not just the US, but the world has to come together with an enforceable way to make sure that we keep humans first, and that we have a paradigm where we have standards of conduct that are in fact enforceable globally with respect to AI.
Okay, thank you, Jerry. I'm moving on then to the next question from Susan Grant, who's Director of Consumer Protection and Privacy, the Consumer Federation of America. Her question: the types of harm being described here are not necessarily a requirement to assert that one's civil rights have been violated. Why should it be different for privacy? Who wants to respond to that?
Well,
Michelle.
go ahead, Michelle, please.
Michelle.
Yeah, I think you're right, Susan, that something that's going to be so narrowly tailored to financial and physical harm might not survive this process, right, and be seen as a compromise. Our data world is just so much more complicated than that, right? The data is fungible. It changes hands at the blink of an eye. It's, cumulative, and trying to tease out who did exactly what with what piece of data and how that influenced someone else. It's just not going to work, and it's not going to be preventive, right? I think we need to stop talking about data is oil and things like that and talk about, data is water, right? We have to keep it clean. We need everybody to behave well, because once it's all out there, we are never going to trace that drop back, right, to figure out where that pollution came from. I think I just made up a whole new analogy for data. But so I think we need to think more holistically about what the harms are. And I would give you just a couple of examples. One, I still am a huge fan of the NIST privacy engineering documents from a couple of years ago that explain what it means to lose autonomy and trust, right? And in that example of loss of trust is no one's going to use COVID apps, right? Here we are in the middle of a pandemic. Millions of people are going to die, and no one's going to put that stuff on their phones. That is a very clear outcome of the system we've built now. Maybe no single person will be sued from it, but I think it's a good example of how the cumulative effect of a lot of bad actions over time have really put us in a bad situation.
Thank you, Michelle. Cam, you wanted to come in as well?
Yeah, I do part company with Jerry on limiting things to economic or physical harm. As Michelle said, there are broader harms in privacy, but I think the analogy to civil rights law is an important one, because one of the challenges in civil rights law, and I've been counsel in civil rights cases, is it can be difficult to prove damages. It's hard in, say, a First Amendment case to show economic, damage that can be measured, harm that can be measured by damages. But that's where the injunctive relief that Jerry has talked about is a vital component to the relief that's available in legislation. So you can vindicate the harms, even if those harms can't be quantified in money.
Right. Thank you.
Yeah. Causation is an important consideration here, as Michelle was mentioning, and it is hard to prove. I'll give you an analogy. I was defending a case where a company was being sued for causing cancer. And I will never forget the doctor's deposition when he said, you know what, I have no idea what caused this person's cancer. I have no idea, because there's so many things that happen in the environment. And I said, so doctor, you're saying there's no way you can show my client, and the case was over. And that is a complexity that we deal with. So causation is a fundamental principle of fairness. And you can't hold somebody responsible for things that they did not cause. So we've got to be able to deal with, that concept.
Right. Well, on that one, I think we have a comment from Anne Vroom, principal of Vroom Consultants. You pose it as a comment, Anne, so I'm not sure if you expect a response from the panel, but let's see how it goes. So you say, Anne, in my view, any legislation that precludes a private cause of action and substitutes a quote-unquote capped fines is just an industry shield. Anybody want to react to Anne's comment?
Well, a couple of things. I mean, look, I think it's in the nature of getting legislation passed that it takes some compromise. I think the kind of thing that we've outlined in the Brookings report would vindicate harms, recognized harms. I agree with Jerry that statutory damages, damage multipliers, can result in a lot of nuisance value to cases, where there's not necessarily a lot of tangible harm, but that in serious cases, in knowing or willful violations of the statute, it makes sense to have statutory damages so that you are policing bad actors.
Okay, we're running out of time. I've been very good for a change and not monopolizing you and not asking any of you actually questions really, and giving the floor rightly so to the people watching and listening to this discussion. But in the couple of minutes left of us, so all of you, including Jerry, have to be very concise and brief, okay? I was intrigued by, Michelle used the phrase, I'm paraphrasing slightly, Michelle, forgive me if I misquote you, that we'll have to see, or just interesting to see whether industry gets in on this regulatory moment. And if any of us were listening to Commissioner Wilson and Senator Brown, it's pretty clear that a lot of people are focusing on, there's an issue there to be addressed, let's put it as simply as that. And in the view of the panel, do you think we've reached a stage now, for many different reasons, as Sheila was saying, the pandemic has flipped the script, to use her phrase. The industry now is trying to play a constructive role in trying to shape legislation, not to block it, not to weaken it, but also to be part of the solution, not part of the problem. Briefly, all of you, please react to that.
Yes, look at
Jerry.
the proposal from Privacy for America, look at the proposals from the United States Chamber of Commerce, look at the proposals from the Business Roundtable. American business is moving forward on this issue.
Right, thank you. That was very concise, Jerry, thank you. Michelle, Sheila, Cam, who's next? You're gonna get a chance to speak. Michelle.
Yeah, I'll jump in just quick to say, I think this really differs depending on the type of company or the trade association. They're frankly all over the place, and some of them are not serious. I think some people are trying to game the politics of, we'll stay really, really conservative on this stuff and drag everybody with us. And this is not helping. It really is not. I think the ends need to do more work to come together and find the solutions to the hard problems. And that means everybody's going to have to give a little bit here.
Okay. Sheila?
I'll jump in and say, agree. There's a lot of good work going on. So I agree with Jerry. And then there's still some division and some position holding by certain groups. So I agree with Michelle. I do think it's time for everyone to come to the table and for us to develop a unified position. I want to throw one more. I think P4A, great initiative. Cam's bill is great. The Chamber's done incredible work. Business Roundtable, incredible. I love what they did last fall, changing their charter from businesses exist to serve shareholders to businesses exist to serve people. And I think that really has to be the lens and the focus, and getting business unified around an engagement.
Okay. Well, Cam, you're getting all this recognition.
Looking back at trying to push legislation during the Obama administration, this is night and day in terms of where business is, and it's come a long way. And I think there's a lot of business that really does want to see legislation of some kind, consistent national legislation. It's partly about preemption, but I think for business, this is also about trust. That cascade of data breaches, scandals like Cambridge Analytica have eroded consumer trust. It's eroded the brands of American businesses abroad and around the world. And I think people are on both sides of the debate are looking for a consistent, firm basis to be able to trust how data is being used.
Thank you, Cam. Well, we have to bring this to a close. My thanks to Cam, Michelle, Sheila and Jerry. My thanks to all of you for watching and listening out there. Special thanks to those of you who asked questions. We now have a short break, and I hope you'll be back for the keynote address at, is it 4:50? Where are we? Take away 6 hours from 10:50 with Congresswoman Kathy McMorris Rogers. Thank you all again, and see you very soon. Bye-bye.
Thank you.
Thank you, Paul.
Thank you.
Take care. Bye.